Mr. Evans has indicated that he'd like to represent himself on this matter and have our office as standby. I think the court granted that motion, but set this hearing to today because Mr. Evans indicated that he sent a letter to the court that had some requests in it. I don't know if the court received it and if a copy was provided to the city. I have not seen it.
I have not seen it. I looked in the court file earlier today and it was not there. Madam Clerk, do you know if we've received it?
I don't know why you guys haven't received it. Also, can I ask that this hearing is on record and that everything is being documented by a court reporter, please?
We do not have a court reporter. We're creating an oral recording, though.
Okay, so will it be on record and
Yes.
Will it be able to be reviewed by federal judges if?
Welcome back to Courtroom Uncut, where we peel back the layers of legal chaos one gavel bang at a time. Today's case? A self-represented defendant, Mr. Evans, claiming tribal sovereignty and demanding the court recognize his royal immunity. From missing letters to a PR bond request wrapped in sovereign rhetoric, this hearing is a procedural minefield. You'll see the judge maintain firm control, balancing respect for self-representation with the hard limits of law. Pay attention to how she separates belief from burden of proof and how quickly courtroom patience wears thin when procedure collides with ideology. Buckle up, this one's wild.
I had very personal and sensitive information regarding my sovereignty as a chief of a sovereign tribe that's federally and internationally recognized. I don't know why that letter didn't make it to you. I mailed it out last Tuesday, so it should have definitely gotten to you guys by now. I'm having issues with getting to the law library. I've been in the hole. It's like almost impossible for me to legally defend myself with the conditions within the jail. One thing I would like to ask, especially being that you didn't get that letter and I invoked my rights as a sovereign tribe, chief of a sovereign tribe, that if possible, you can give me a PR bond so I can properly get everything to you and make sure it's filed in the courts. I assure you, being that I invoke my rights as a sovereign tribal chief, that I will appear at court dates. I won't play with my rights like that. I have too much to lose. And I have a leg injury. But the main thing is my legal part and the getting the proper defense, and then the mail that I'm mailing out, it's not even getting to you. So I know I'm gonna have an issue defending myself from the inside of this jail. If you could do that for me, I humbly, respectfully ask that you give me a PR bond so I can at least properly.
Things take a sharp turn. Mr. Evans invokes his sovereign tribal chief status, a familiar tactic in pseudo-legal defense circles, arguing that his incarceration violates his self-governed rights. The judge doesn't dismiss him, but she's laser-focused on one thing: changed circumstances. Without new evidence or facts, prior bail rulings stand. This is textbook courtroom discipline. Judges can't grant relief based on identity claims or personal hardships alone. They need verified, admissible evidence. What's interesting here is the tone. The judge isn't mocking, she's methodical. Watch how she tests claims with calm questions that cut through.
Yesterday, and I just forwarded it to all parties.
Okay, thank you. I'm going to take a moment to look at that then. I didn't see it in the file.
In addition to that, I introduced evidence that will exonerate me.
Mr. Evans, I can't read it and listen to you at the same time.
I'm sorry, Your Honor. Also,
Sir, I can't read and listen at the same time. I read slowly.
sorry.
Okay, I've read your letter. You've already had at least one bail hearing, because I remember it. I have not heard any change in circumstances such that you're not entitled to a second bail argument. Bail remains as previously set, $500 per charge. What tribe are you enrolled in?
All of that, I don't want to reveal that information because it's private. That's why I invoked also the Peace and Friendship Treaty between the United States and Morocco, in which I do qualify for that. And also you can contact the Embassy of Morocco.
No,
and they-
so I'm familiar with that treaty, and it is a trade treaty. It has nothing to do with your right to commit crimes anywhere you feel like.
No, ma'am. It has nothing to do with me committing crimes, but they will vouch that I am royalty, and Morocco has granted me as part of their royalty, and they will vouch for me. I assure you.
You can't be a
The viral moment, the Morocco Treaty argument. Evans references the Peace and Friendship Treaty of 1786 between the U.S. and Morocco, insisting it grants him immunity as royalty. The judge immediately corrects the record. It's a trade treaty, not a get-out-of-jail-free card. This exchange is a masterclass in judicial patience. Instead of escalating, she uses logic to expose the flaw. Treaties regulate nations, not individuals. This is where online courtroom watchers often pause the video and ask, does he really believe this works? Maybe. But belief doesn't override jurisdiction. The law demands evidence, not mythology.
So I'm not going to.
And
I'm
the
not going to
letter.
grant. I'm not going to grant your motion to dismiss.
Okay.
What are we doing?
Okay. And I submitted evidence in the letter.
I'm not denying. I'm not granting a motion to dismiss.
I understand, but I submitted evidence in the letter as well.
I've considered your letter, and I'm not granting your motion to dismiss.
I understand.
Okay. What are we doing?
What about the evidence?
What do you want me to do with the? I don't have any actual evidence. I have your statements.
Right. I submitted evidence in the letter. If you read it, you'll see that I submitted a civil case as evidence.
You submitted. You mentioned a civil case. I don't see the civil case. I have no access to this case.
I submitted civil case 24012 out of St. James Parish, Louisiana, as evidence that will exonerate me. And in addition to that, it will prove everything that I'm saying to be true.
I don't have that case, sir, is what I'm telling you. All I have is your letter.
Right. In the letter, I submitted civil case 24012 out of St.
Sir, I don't have that case in front of me. I don't know what's in it. I have no access to it. All I have
You have
is
to retrieve it.
I have no way to do that.
You have to contact the courts.
Sir, that's your job. This is your case. You represent yourself. It's your job to put your case together. It is not the court's job. I cannot, I'm ethically.
The classic sovereign citizen feedback loop. Mr. Evans keeps referring to evidence he says he submitted in a letter. But letters aren't evidence. Documents must be filed, timestamped, and entered into the record. The judge can't act on claims about unseen exhibits. When she says, I can't read and listen at the same time, it's more than politeness, it's a procedural safeguard. Judges can't simultaneously evaluate testimony and review new materials. The defendant's frustration is real, but it highlights the cost of going pro se. Without legal training, even valid points drown in misfire.
012 out of St. James Parish, Louisiana, as evidence that will exonerate me.
Then you have to actually get that case and put it before the court.
It's impossible for me to do that inside jail.
You have a standby counsel. Perhaps you can talk to him about it.
Are you going to be able to retrieve that case for him?
1 second. And Your Honor, I can make the records request. I don't know if it's going to have any luck receiving it. I mean, based on the information that I have.
The case has a seal on it, and you're going to have to get permission from the Chief Justice Roberts to get the seal broken.
I don't understand what the U.S. Supreme Court has to do with a Louisiana state case.
Because it holds my rights, as my constitutional rights and privileges as a chief of a federally and internationally recognized tribal chief, in which I represent a sovereign state.
Okay, so what are we doing today?
According to the letter, if you're not going to dismiss it, I asked that in the letter I requested that you file a motion of discovery.
I can't file any motions. I'm not an attorney. I don't represent you. I don't represent the city. That is not my role.
Okay, and you said you're not dismissing due to lack of evidence.
Correct. I have read the police reports and did find probable cause to detain, and some of these cases are in review.
Educational value spikes. Mr. Evans asks the judge to file motions for discovery and suppression, not realizing that once you go pro se, you are the lawyer. The judge patiently explains she can't draft or submit motions on his behalf. It's a tough love moment that underscores how technical criminal procedure really is. Viewers, this is why judges warn defendants before granting self-representation. The freedom comes with full responsibility. Miss a filing deadline, use the wrong form, or mislabel a motion, and the system won't stop to fix it.
Okay, so what are we doing today? What's the plan going forward?
The plan going forward, I would like a fast and speedy trial by jury. I would like a motion for discovery to be filed. I would like a motion to suppress.
Sir, you represent yourself. You have to file those motions. Nobody. You asked to represent yourself. You got Judge Rose Akins granted that. So it's up to you to file those motions.
Okay, I just received the paperwork from Mr. Iannetti today on the format to file those motions. So I'll have those motions mailed out tonight.
Okay, perfect. All right, so we're setting this for trial, is what I'm hearing.
By jury.
Okay, so only the pretrial cases are going to be set for trial. I see the pretrial order has all the case numbers on it. Or does it have only the pretrial one? Okay.
I just clicked on it to give him an example of that order as well.
No, I think you've got all the right ones on here.
Okay.
1-5.
And I also asked that that letter be sealed due to the fact it has sensitive information on there regarding me and
You
my
have to
family.
file a motion to seal it, sir. I'm sorry, but this is why it's best not to represent yourself if you don't know criminal procedure. There's a whole process. There's a whole process to having something sealed. I have to make certain findings. I don't have that motion in front of me.
Okay, I requested it in the letter, but I'll file a motion as well.
Okay. But I'd encourage you to read the Bone Club case so that you can understand what the guidelines are for sealing.
I haven't received any of that information, and also I need access to the law library, which is like they don't.
Deep in the logistics now, multiple charges, multiple cases. The court wants efficiency through joinder, combining cases, but Evans objects, preferring separate trials. The judge explains that means months more in custody. It's a tactical decision with real consequences. Separate trials can preserve defense flexibility, but at the cost of time and risk. The beauty of this moment is how transparently the judge explains each trade-off. She's not forcing him, just showing how the calendar dictates reality. Every courtroom has this push-pull. The law promises fairness, not
Will the city, first of all, is there a motion to join and consolidate these cases for trial?
Yes.
Any objection, Mr. Evans?
Yes, I do have an objection.
So then you realize it'll take roughly 4 months to try these cases.
Will I be sitting in jail the entire 4 months, or is it 60 days still?
The problem is we can't try if you're not going to agree to try them simultaneously. I can't guarantee you they'll all be tried we only do jury trials 1 week out of the month.
But my question is, will I have to sit in jail 4 months or 60 days?
Potentially 4 months. I can't rule that out. And I'm not trying to pressure you into agreeing. I'm just setting out the facts. You do what you want to do.
I just explained what joinder means and the benefits and disadvantages of joinders.
So, Mr. Evans, what do you want to do?
I want to do them all separately.
Okay. We'll set them. Here's what I'm going to suggest then. I'll put this out to you guys. You tell me what you want to do. Set them all in the June term. And then whichever one goes. But we'll have them all set so that it'll depend on who's available and such. Okay. But they are not joined that unless somebody files a motion to actually hear it. But as of now, nothing is joined. Okay.
Yes, Your Honor.
So the readiness hearing will be on June 12th.
Sit out here.
And jury trial beginning the week of June 24th. And we'll have a hearing on admissibility we'll have a 3-5 hearing. That's a hearing about any statements you may have made, Mr. Evans. And a hearing on admissibility of any 911. I don't know whether there is or not, but just in an abundance of caution. Will you be filing any motions to suppress under Rule 3.6?
I'll be filing motions to suppress and subpoena.
Are there additional witnesses you'll be calling?
Yes, ma'am. I would like to subpoena the airport director or the operator.
Into confusion about affirmative defenses. Evans insists his presence at the airport was legal, calling it a defense, but technically, it's a general denial. The judge explains the difference. An affirmative defense admits the act but provides legal justification. His is simply, I didn't do it. Then comes the twist, he requests a court reporter and plans to appeal. The judge reminds him this isn't Superior Court, recording substitute transcripts. It's a stark look at procedural hierarchy. The judge keeps decorum, while the defendant keeps circling back, searching for validation. The record
To put the city on notice of who the defendant will be calling?
No,
Okay. What would you accept? I don't know how to put this because I don't think Mr. Evans knows who this is right now.
I believe the onus is on
director
the
of the
defendant
airport.
if he wishes to identify and subpoena that individual or individuals.
Okay, so as soon as you figure out who it is, you have to put the city on notice.
Lance Little, the managing director of the airport.
Okay. T-Tech Airport Managing Director Lance Little. I've included that.
Got it.
Will you be offering any affirmative defenses?
Is that a question to me or the?
Yes, it is. It is.
What's your question again? I'm sorry.
Are there any affirmative defenses?
Could you reword that, please?
Perhaps Mr. Ainati can help.
Yes, 1 second.
Yes, ma'am, I do. I will be providing an affirmative defense and the right that I was a law-abiding citizen at the airport.
So I think that's general denial. That's not an affirmative defense.
Well, also that I was a passenger of a business that operates legally in the airport, of a charter bus company that legally operate. I was a customer of a charter bus company that legally operates in the airport.
So still, that's just general denial. That's saying I didn't do it. Not an affirmative defense is saying you did it, but there was that you're allowed to do it.
Right. I was at the airport, and the reason why.
So that is general denial. That is saying there was no crime that was committed. That's what you're saying, right? That you did not commit any crime.
No, I'm saying that I was a customer.
close. The judge resets the record, finalizes trial dates, and reaffirms her ethical limits: no investigations, no hidden evidence hunts, no shortcuts. Mr. Evans will need to produce his own exhibits or coordinate through standby counsel. It's a clean procedural landing after nearly 20 minutes of turbulence. This hearing shows how courtroom reality collides with sovereign theory and how patient.
Airport for safety. It was necessity is an affirmative defense.
Okay.
Lawful use of force is a defense.
In that
Just
case,
saying I didn't do it, I was allowed to be there is not an affirmative defense. It's a defense. I'm not saying that it's not a defense. I'm just saying it's not technically an affirmative defense such that you have to put the city on notice.
okay, according to your definition, I guess it's not an affirmative defense. But once again, could they close the door so I can make sure I'm hearing? Can I re-verify that everything is being recorded and that everything's on file? And I would also like that a court reporter be present for all future hearings and possibly for this one as well, if possible.
We will not have a court reporter. We are not required to. We are not a superior court. We don't have a budget for that. We record everything. Everything is recorded. But we do not have a court reporter. We do not have access to a court reporter, and I'm denying that request.
Yes, ma'am. And then also, could I file a motion to appeal that?
You have to actually file it. You don't need my permission to file a motion. You can just file it.
I mean, a notice to appeal. I'm sorry. So I would get that information from Mr. Ionetti because I don't have any access to the law library to get these motions or notice of.
Sir, you have to have a basis in law to request that. I can't imagine. We are not courts of record in that sense, like a superior court. We do not have court reporters.
I understand, but I feel my constitutional rights are being violated.
So there isn't a recording of everything. Everything can be recorded and transcribed, but we don't have a real-time court